One of the documents we use in a real estate transaction is arbitration. What is arbitration? Simply put, if there was a dispute between the buyer and seller after closing, how do we resolve or handle that dispute? It's not enough to say, when I moved into the home, the roof leaked, or I had water in the basement. As a buyer, you have to demonstrate that the seller knew about the issue and either didn't disclose it and misrepresented it. That can be a tough burden to demonstrate. However, we handle it in one of two ways. One is arbitration, the other is the court system. There are pros and cons to both. In arbitration, you generally get an arbitrator or a panel of arbitrators that meets you and the other party at the home, in an office, hears both sides of the case, and then makes a decision. The main difference between arbitration and a court proceeding is that arbitrator's decision is final. There is no appeal process. Unlike the court system, a judge's decision can be appealed and appealed and appealed. I've seen a couple of instances where the cost of that proceeding far exceeds what the two parties are debating. Again, the main ramification is if you come out on the short end of the stick in arbitration, it's final. There's no recourse. So when you are agreeing to arbitration in a purchase agreement, you are giving up your right to the legal court proceedings. That's just something to be aware of. I generally advocate for arbitration. In most situations, I think it is best served. It's a cost quantifier as well as a more timely response. However, there are instances, there are scenarios where obviously the legal system is of benefit. In a real estate transaction, the form that we put in front of you, a buyer or seller, is if the dispute is over $15,000, would you agree to arbitration? What you have to think about is, does that meet the needs of your situation and your home when you're looking at buying or selling a home?